Hello friends, welcome back to EduTap. So before proceeding ahead, I would like to give you the context in which this session is introduced. Most of the aspirants, when they start preparing for SEBI grade examination, the most often question that they ask is, sir, where can I find the previous year questions? So this is a series where we have brought the PYQs of SEBI grade examination, both phase 1 and phase 2, that is subject wise. So friends, in this session, we will be discussing the Companies Act PYQs that have been asked in specifically in the phase 1 of the examination, that is of paper 2. I think you must be aware that all the 6 subjects appear in the paper 2 and paper 1 comprises of the QRE English section. So friends, let us proceed ahead now. So let me provide you a basic information regarding SEBI Grade A guidebook that we have brought. This provides the complete answer to all your questions, complete and definitive answer. So this book, the SEBI Comprehensive Guidebook, will help you prepare in 3 important ways. First is it saves your time, and it also saves your effort, and most importantly you will get the complete information regarding SEBI. The information comprises of the examination pattern, the information about the institute, and rest everything is available in this SEBI comprehensive guidebook. So friends, the good thing is this is available at free of cost. And where can you get this from? So the link for this book is available in the description box below. You can download it from there. So now friends, let us proceed ahead with the PYQs of 2022, that is of phase 1 SEBI grade A examination. So now let us look at the question. So as per section 174 clause 1 of the Companies Act 2013, the question says the quorum for a meeting of board of directors of a company shall be dash of total strength or dash directors, whichever is higher. So I want you to pause this particular video at this point of time and think for yourself what could be the answer. Anyways, even if you do not know the answer, we will discuss this based on the entire learnings that you take from the previous year, this session, that is the PYQs of the Companies Act. You can strategize your preparation in the coming time, friends. So that is the main motive and objective behind coming up with this particular session. So friends, the answer to this particular question is option B. So section 174 of the Companies Act categorically states that the quorum, what exactly do you mean by quorum? See, quorum. The number of board of directors can be anything up till the maximum number is 15. In public companies, in private companies, and in one-person companies. So the maximum number of directors who can be part of the board of directors is 15. See, in order for the board of directors to assemble together and start a discussion on anything, there needs to be minimum number of directors present in order so that the discussion can proceed ahead on any topic. So that minimum number of directors who must be present is known as quorum. I hope that you are clear with that term. So quorum for a board meeting must be 1/3 or the total number or 2 directors. Total numbers, 1/3 of the total number of directors or the 2 directors. Suppose for example, if there are 15 directors, 1/3 of 15 is 5. Or 2 directors, whichever is higher. Since in this particular case the 5 is the higher number, so there must be minimum 5 directors who must be always present at the board of directors meeting, so that the company can start ahead with the discussion on any agenda or any topic. If the strength is suppose 4, then the board of directors cannot proceed ahead with the meeting. They will have to suspend the meeting and maybe reschedule the meeting on a certain other date where the minimum where the quorum is observed or quorum is present. So friends, always remember, this is a very important question. The kind of question that can be asked in the exam is, they keep testing whether you know the basic facts or no. So the quorum for board meeting must be 1/3 of the total number of directors or 2 directors, whichever is higher. Hence the answer is option B. Therefore, suppose again here the example is given, there are 3 directors. 1/3 of this is 1 and their option is 2. So which is higher among this 1 or 2? since 2 is the higher number, there must be minimum 2 directors who should be present in order for the board meeting to happen. So even if the directors are not physically present but take part in the meeting via any audio visual means, they too shall be considered as a part of quorum. So friends, this is a very important chapter, board of meeting from section 173 to 195. You must be thorough with this particular chapter. I hope now you understand this particular question. Let us proceed ahead with the question 2. The question reads that an auditor appointed at AGM, which is annual general meeting, shall hold the office from the conclusion of first AGM till the conclusion of dash AGM. This is from the chapter of auditors, chapter 10, audit and auditors. So the options are 5th, 6th, 3rd, 4th, none of the above. I hope you must have pondered over this particular question. The answer is, friends, option B, that is till the 6th AGM. See, the section 139 of the Companies Act deals with this particular provision, where it states that every company shall appoint an individual or a firm as an auditor of the company at the first AGM, and the person so appointed shall hold the office from the conclusion of the AGM in which he was appointed till the conclusion of 6th AGM. So you know, one important inference can be drawn from here. The inference is that the tenure of the auditors is 5 years, friends, 5 years. And the this is in case of non-government companies or the private companies. And the appointment of auditor is different in government companies. So let us not get into that. So we will only stick to the discussion that has been provided by the question, because again this would lead to a lot of confusion. So you know, the important idea behind this particular session is you will get an idea that what are the kind of questions asked in the previous year examinations, and based on that you will strategize your preparation for the coming year, friends. I hope this is very much clear. This is a direct question, from the section 139. If you go through that, you will clearly you would have found out this question was very easy. Now let us proceed ahead. Which of the following is the minimum qualification for a person to be appointed as a president of National Company Law Tribunal, friends? And the options given are Judge of High Court for 5 years, Judge of High Court for 10 years, Judge of District Court for 5 years, Judge of District Court for 10 years, and option E is none of the above. So I want you to pause at this particular point of time and think for yourself what could be the answer if you have read it in the past, or else anyways we are going to discuss the answer. So friends, here the answer is option A, that is Judge of High Court for 5 years. See, this comes from the chapter NCLT section 409. If I were to speak precisely, it talks about the qualification of the president and members of the tribunal. See, in order to be a president, a person who is or has been a judge of high court for 5 years is the qualification. This is a very important fact. You must remember this. And questions can also appear from what are the minimum qualification for judicial member and what are the minimum qualifications for technical member. See, in order to be a judicial member, so NCLT comprises of 3 types of member, as it is mentioned: president, judicial member, and technical member. For president, we learnt that the minimum qualification is who is or has been a judge of high court for 5 years. And apart, if it comes to judicial member, a judge of high court at present or in the past, or district judge for at least 5 years. This is another important fact: at present or in the past. Advocate of a court for at least 10 years. So friends, this is a question that can be asked in the upcoming examination also. So you must remember these sort of facts. And when it comes to technical member, you must remember that member of Indian Corporate Law Service or Indian Legal Service for at least 15 years. This is another important fact. And has been holding the rank of secretary or additional secretary to the Government of India. Practice as chartered accountant, CA, again cost accountant, company secretary. The tenure is common: 15 years, 15 years, 15 years. And the person who is capable and has professional experience of again not less than 15 years in industrial finance, industrial management, industrial reconstruction, investment and accountancy. Presiding officer of labor court, tribunal or national tribunal constituted under the Industrial Dispute Act for at least 5 years. So friends, these all are the very important facts you must remember and revise multiple times so that you do not miss out on a particular question if the question is coming from these sort of facts. I hope that is very much clear. Now let us proceed ahead with the next question. A company shall not at any time vary the terms of the contract referred to in the prospectus or objects for which the prospectus was issued, except subject to the approval of or except subject to the authority given by the company in. Options are general meeting by way of special resolution. Option B is general meeting by way of ordinary resolution. Option C is board meeting by approval of board of director. Option D is annual general meeting by approval of board of director. Option E is none of the above. So kindly pause this particular video for a particular certain time period, then think upon the answer for yourself. So the friends answer here is option A. This deals with the chapter 3, that is prospectus. I hope you must be aware with the word prospectus, which is issued by a company before the company goes out for any IPO. So once the prospectus is issued, the section 27 tells that variation in terms of contract or objects in prospectus. So if the prospectus is already issued and now if certain changes are to be made within the prospectus, then what is the procedure behind that? So company shall not at any time, see, first of all it gives precaution that you cannot or shall not at any time vary the terms of the contract referred to in the prospectus or objects for which the prospectus was issued, except there is a certain exception that is being talked about here, subject to the approval of or except subject to an authority given by the company in general meeting by way of special resolution, friends. So it is clearly mentioned, hence the answer is option A. Now, and apart from that, provided that the details as may be prescribed of the notice in respect of such resolution to shareholders shall be also be published. So what this point is trying to say is, suppose there are certain changes made in the prospectus. Now such changes have also to be published in the newspaper, one in English newspaper, the other one is in vernacular. For example, the company is headquartered in, suppose say, let us say it is headquartered in Mumbai. So it can publish the changed aspects in the prospectus in one English newspaper, and apart from that, one vernacular is, it can be Marathi when it comes to Mumbai. So I hope that is very much clear. And now coming to the second point, it says that provided further that any such company shall not use any amount raised by it through prospectus for buying, trading. This is not an important one. Now this is another important point, dissenting shareholders. So again, this is a part of section 27. Clause 2, it says that now once the company wants to vary the terms of the contract or vary the terms of the prospectus, there are certain shareholders of that particular company who do not want that change. So they are known as dissenting shareholders. So dissenting shareholders being those shareholders who have not agreed to the proposal to vary the terms of the contract referred to in the prospectus. So now once you recognize that these are dissenting shareholders, the promoters of the company, that is the owners of the company, should provide them an exit. So these anything under the sun can be a reason because of which these shareholders might be dissenting, that they do not want the variation in the contract. If the company still wants to go ahead with the variation, then the dissenting shareholders need to be given an option that you can leave our company being or exit as a shareholder of our company by providing an exit price and in such manners as the procedure may be specified by SEBI. So friends, I hope this is very much clear. The important fact here is general meeting by way of special resolution and who are the dissenting shareholders. This is again a possible questions in the upcoming examinations. Now having discussed this particular question, let us move to the next question. According to section 47 of the Companies Act, every member of the company limited by shares and holding equity share capital therein shall have a right to vote on every resolution placed before the company, and his voting right on a poll shall be in proportion to his share in the dash share capital of the company. Is it the called up capital, paid up capital, issued capital, authorized capital, or none of the above? So friends, I want you to pause at this particular point of time and think for yourself. I hope you would have done that. The correct answer here is option B, that is paid up capital. Let us look at this provision. This is asked from the section 47 of the Companies Act, again coming from chapter 4, share capital. So this is all a technical language. You need not remember know that every member of a company limited by shares and holding companies shall therein have a right to vote on every resolution. These are important keywords, friends. So if you are a shareholder of, say, Reliance company, so you have a right to vote on every resolution which has been placed before the company. And not just that, and what shall be your voting right on a poll? It shall be in proportion to the paid up equity share capital of the company. It is how much you have paid. It will be in proportion to that, not the called up or issued authorized. I hope you must be familiar with the paid up equity share capital of the company. So friends, now let us move ahead with the question 6. If the company fails to distribute the declared dividend, then every director of the company shall, if he is knowingly a party to the default, be punishable with. So imprisonment is a common term here, imprisonment, and the tenure here option is varying. Imprisonment may extend to 3 years and with fine which shall not be less than 1000 rupees or for every day during which such default continues. The key words that you have to note down here is imprisonment given to a director, is it of 2 years or 3 years or 5 years, and fine, is it 1000 or 2000. That those are the two elements, you know, that they have been changed here. And friends, the correct answer here is option B. Okay, which is imprisonment. Okay, here it is saying 2000. No, the correct answer is option C, because friends, it is 2000. So now what exactly is this provision saying? This provision comes from the declaration and payment of dividend, declaration and payment of dividend chapter. So important thing is, whenever a dividend has been declared by the company but has not been paid, or a warrant in respect thereof has not been posted within 30 days from the date of declaration to any shareholder entitled to the payment of payment of dividend. Suppose this is a Reliance company. I am just giving you an example. You know, it has already declared the dividend. Then the dividend is supposed to go to a particular shareholder, suppose say A, and you know, it has this particular shareholder has not claimed the money of dividend within 30 days. Then the company is supposed to place that the shareholder is supposed to get a dividend of this particular amount on the website of a company. So here it is saying that where a dividend has been declared by a company but has not been paid, or the warrant in respect therefore has not been posted within 30 days from the date of declaration to any shareholder. So if the particular shareholder is not taking the amount from the Reliance company, then within 30 days after the company has to post it on the website of that particular company that 30 days have passed away and still you have not claimed your dividend, so we are posting it, kindly take it from the company. So now if it is not done so, then every director of the company shall, if he is knowingly a party, see, every director of the company can be, there can be two possibilities. Company has declared a dividend and the pertinent shareholder has not got the money. So who can be held responsible that person has not got his dividend? It is the directors of the company. So now director of the company might know this, might be aware of this phenomena, or might not be. So it is, the language is clearly mentioned here. Every director of the company shall, if he is knowingly, that director also knows it, if he is knowingly a party to the default, be punishable with imprisonment. See, imprisonment is you are put into jail, which may extend to 2 years. See, the language is which may extend to. So he might be initially imprisoned for 6 months, again might extend to 12 months. So maximum extension is 2 years, and with fine which shall not be less than of rupees 1000 for every day during which such default continues. And the not just that, the company shall also be liable to pay a simple interest, again a keyword, at the rate of 18% per annum during the period for which such default continues. Suppose you are a shareholder. On 21st March the dividend is declared, 21st March 2023, and the person has not got the dividend even after 30 days, suppose 21st April 2023. then after that any delay in further payment of dividend to the particular shareholder will not only just the shareholder might will not only get the amount, but also because of the delay in the amount to be paid back to the shareholder, he would also be paid an interest rate, and that interest rate would be simple interest rate at the rate of 18% per annum. Again, a very important provision, friends, coming from the chapter declaration and payment of dividend, section 127. Now let us move ahead with the next question. According to the provisions of the Companies Act, a company which has been in existence for not less than dash financial years may contribute any amount directly or indirectly to any political party. The options are 1, 2, 3, 4 and 5. So let us look at the answer. So friends, the answer is 3 financial years. Option C. So this is dealt by the section 182 of the Companies Act. It contains provisions regarding the prohibitions and restrictions on the political contribution by company. Section 182 clearly states that certain companies prohibits certain companies to make a political contribution, as well as restricts some companies to make political contribution subject to the compliance. So the key important thing that you must remember is, suppose election is happening in 2024, elections might happen. There are majorly two parties, one is BJP and Congress. It is saying that any company can make a contribution to these respective political parties, but there are certain conditions. Some set of companies are not eligible for this political contribution, and what are those? A government company, example LIC, ONGC, and many other such government companies. And not just that, the other important fact is a company that has been in existence for less than 3 financial year. Suppose election is happening in 2024, and in 2023 a company is opened up, and within 1 year now it cannot provide the funding to any political party, because that has been prohibited by the Companies Act. Let us not get into further details with regard to this, but you must remember this particular fact, that government company and the company that has been in existence for less than 3 financial year cannot contribute to the cannot make political contributions. That is a very important fact. Now coming to the 8th question, friends. A director who has stayed in India for at least dash days during a financial year is referred to as a resident director. I hope you are aware about what exactly is a financial year. Financial year starts from 1st of April, say let us talk about this year 2023 to 31st March 2024. So this is 23-24 financial year, and there is one more term named as calendar year that starts from 1st Jan to 31st December 2023. So this is a calendar year, and financial year is from 1st April to 31st March. So friends, a director who has stayed in India for at least dash days during a financial year is referred to as resident director. Here the answer is option B, friends, 182. So this is coming from section 149 clause 3 of the Companies Act, which requires every company to have at least one director who has stayed in India for a total period of not less than 182 days in the previous calendar year. So it is mentioning that previous calendar year, and the question here is saying during a financial year. So this is the wording of the Companies Act, friends. There is a certain error in that particular question, that was asked in the examination. So the Companies Act clearly says it is calendar year. So let us you can look into this particular aspect in detail, that is section 149 clause 3. And not just that, friends, there are many types of directors such as independent director, executive director, non-executive director. So you can study about all those aspects. So this was all with we had with respect to the previous year Companies Act session. So now in the next session we will be dealing with the phase 2 questions. These were the phase 1 questions that have been asked in the 2022 examination. Now in the next session we would be discussing the phase 2 2022 examination questions. So that's all we have from this particular session. Thank you.